Hello humans, I'm the Recruiting Maven and welcome back to my channel. Today I'm going to discuss how you can identify if your company might be planning to lay you off even before you receive an official notice. Please know that your employment status has nothing to do with your self-worth or value. For those of you who are new to my channel, this channel is focused on exploring solutions and discussing various options regarding the transformations occurring across all industries due to the widespread adoption of artificial intelligence. As AI integration becomes increasingly common in the workplace, it's crucial to recognize that this shift will have a significant impact on individuals across all professions, of which we're already seeing a lot of job displacements. So let's dive into today's topic. So how can you anticipate an employer's intention to lay you off in advance? The WARN Act essentially helps employees access their employer's notice of intent to lay off employees up to 60 days prior to the event happening. The rule is for any employer that is going to lay off more than 100 workers, they're required to give a 60-day notice. It's a federal law, but I would check your local state for additional information. So for example, if you're in California, the requirements are much higher, of course. So keep in mind that you should do some research as every state is a little bit different. You can easily find this information by simply conducting a web search. Just plug in WARN Act plus your state name and that should return the relevant site. Once you access the site, it will provide you with a list of employers in your state who have filed a notice of intent. So let's dive into the details surrounding this. There are so many reasons why a company would lay off its workforce, like a restructuring of a company, perhaps your company has been bought out. Maybe the VC, the venture capital firm that the company has obtained their funding from, pulls the plug on funding, and then again, downsizing, restructuring will happen, or in some dire cases, the company will close. But of course, there's so many reasons why an employer would lay off its workforce. The list is endless. For those of you who are contract workers, this can be a little bit trickier to navigate because your employer of record typically is a staffing company. And so you're not considered a full-time employee of the company that is filing that WARN notice. If right about now you're saying to yourself, hey, that's me, then here's a quick explanation of what you can do. You wouldn't receive any compensation or separation benefits like you would if you were a regular full-time employee. However, if the agency you're contracting with doesn't have any more work for you, then you will typically qualify for unemployment benefits. I would still recommend for contract workers to keep an eye out for those WARN notices as well so that you can start to plan ahead. For those of you who are regular employees of the company, you can expect that the company will give you a 60-day notice, and thereby giving you a bit of time to possibly negotiate your severance package. And if you can, I would recommend for you to do so. Keep in mind that you can ask, and at the very least they can say no, but at least you tried, especially if you feel that the severance package that they've presented to you really doesn't meet your needs and or expectations. Quick tip for those who have been furloughed. Now, furloughs are a bit different from layoffs. Furloughs are a temporary reduction of the workforce with a potential of returning. And yes, you can and should file for unemployment benefits when you're furloughed, so you have some money coming in. Please know that when you're filing for unemployment, the unemployment department will request your potential return to work date. So consider having that information handy when you're filing. In general, I would recommend that when you're ready to file for unemployment, to make sure you have all of the information regarding your compensation and or separation benefits. I mention this because it is such a stressful time and filling out those forms are not a lot of fun. So my suggestion to you is to be well prepared before you even start filling out those forms. Last time that happened to me, it took me 45 minutes to complete those forms. And I know most people are stressed out about the layoff, and on top of that, having to fill out such a lengthy form is already challenging enough as it is. In the comments below, please share your thoughts and opinions about your layoff, your furlough, anything that has happened to you that will help us to learn from each other and grow. Now, here's something that unfortunately can happen in some cases. And that is that many companies will let you know of a layoff the same day that they file those warn notices, but then pay you for those additional 60 days. That way, the company avoids any litigation and they're staying in compliance with the law. When that happens, it's very challenging because there's no way for you to know that, what's coming, and it gets very challenging, but at the very least, they will provide you with a severance package for those 60 days. So that's kind of nice. And of course, everything is about liability, right? And so the company wants to make sure that the liability aspect of it is shrunk to nothing. Lastly, I want to make you aware that there exists a potential reason for companies not being required to file a WARN Act. So let's break those potential scenarios down. 1, a natural disaster. Oddly enough, a pandemic like coronavirus is not typically classified as a natural disaster. I mean, go figure. Number 2, unforeseeable circumstances. So for example, during the pandemic, many of us were required to stay home, which led to the closure of numerous non-essential businesses, which then led to many businesses shutting down, which directly leads to my next point, and that is number 3, a company facing financial difficulties and or unable to find funding is considered as faltering. To give you a little bit of context, I have 2 scenarios that I personally went through. One company was a startup, and this was like 10 years ago. And the company had obtained a Series C funding, and I don't remember the amount, but it was in the millions. Regardless of that, the VC informed the company that it was withdrawing all of its funding and only gave us a 30-day notice. Startups are great, but you've got to proceed with caution because often there's more volatility in these types of jobs. I've also worked for a company that had financial difficulties, and they decided to pull the plug, and all I received was my unemployment benefits. Also, they were a very small company, so there was no warning of any kind because, as I mentioned previously to you, one of the criteria of the WARN Act is that companies over 100 employees are required to file notice of intent. So for a company that's less than 100 employees, you're going to get nada. I do hope that you found this information helpful, as I want to equip you with the knowledge that you can leverage to help yourself, not just to survive, but to thrive. As I've previously mentioned to you, and that is to always have a side gig. That way you have some income already coming in, which is hopefully going to give you some peace of mind. Who knows? That side gig may turn into a very large company. I know it's happened before, and why not you? Again, I just want to take a moment to remind you that your employment status has nothing to do with your self-worth or value. I would like to invite you to go onto my website for additional resources, like my most recent book, The Job Hunting Journal, which helps you to cope with anxiety while job hunting, as well as ChatGPT, resume prompt guides, and much more. Thanks so much for watching, and I will see you in my next video. Take care and have a lovely rest of your day.